The acronym DICE, D-I-C-E, portrays the parts of an insurance policy. The policy declarations identifies 5 items: the name and address of the insured and insurer, the type of business to be insured, the territory covered by the policy period, the inception and expiration dates and times, and the amount of insurance coverage and the premium. The insuring agreement summarizes covered risks, additional or supplementary coverages, and the insurer's responsibility to indemnify against losses suffered as a result of the perils. Conditions list the responsibilities of the insured, both at the time of application, truthful representations in the application and payment of premium, as well as at the time of loss, notice of and proof of loss. Exclusions and endorsements lists the property, perils, and other hazards not covered by the policy or which have a reduction of coverage in the policy. Who is an insured? Definitions differ between types of liability policies, as will be discussed in each section. Duties of the insured include paying the premium and, in the event of a loss, take all reasonable steps to protect covered property from further damage and keep records. Give the insurer immediate or as soon as possible notice of the loss and a description of how, when, and where the loss occurred. If criminal activity is involved or suspected, notify the police. Cooperate with the insurer in the investigation and settlement of the claim. Allow the insurer to inspect both damaged and undamaged property, as well as books and records. An insurer can often learn as much about a loss by the nature of undamaged property as that of damaged property. Notify the insurer as soon as possible of legal action or possible legal action against the insured. A claimant does not have the right to sue the insurer for failure to comply with the policy unless the insured has been found legally liable. The insurer recognizes and has agreed to pay liability sums owed, and the insurer is not meeting their obligation to pay. Provide a list of legal claims against the property involved. Notify the insurer of other insurance which may also cover the loss and for which pro rata liability might be applied. The primary obligation of the insurance company is to pay all sums the insured becomes legally liable to pay as damages due to risks covered by the policy up to the policy limits of liability. In regards to pro rata liability, when there are 2 or more liability policies on a given risk, depending on the type of policy, claims are handled differently than on a property policy. Liability insurance can be primary insurance or excess insurance. Claims can be handled on an equal shares or proportionality by limits, contribution by equal shares basis. Primary insurance is the main coverage or underlying coverage on a risk. Excess insurance is coverage which starts when the underlying policy's coverage ends, such as an umbrella policy. When there are 2 or more primary policies covering the same risk over the same period of time, policy language determines whether the insurers will be liable for a proportionate or an equal share of a loss that occurs. For example, a bookstore owner has 2 liability policies on his business, $300,000 through Company A and $500,000 through Company B. While browsing through the books, a customer is injured when a rack of books topples over onto him. Suffering a broken leg and arm, the customer sues the bookstore owner for $600,000. How much will each company pay to cover the damages? If the claim is handled on a proportionality by limit settlement, the answer is C. $300,000 plus $500,000 equals $800,000. 300 divided by 800 equals 37.5%, which is Company A's share. 500 divided by 800 equals 62.5% for Company B's share. If the claim is handled on an equal share settlement, the answer is A. Each company pays an equal amount up to the limits of each individual policy. If the settlement in this example were for $650,000, Company B would pay the extra $50,000 because Company A's coverage has been exhausted.
Arbitration or appraisal clause. If the insurer and insured disagree on the settlement amount, they each have the right to select an appraiser to determine the value. If the appraisers disagree, the appraisers select a third appraiser judge called the umpire appraiser or court to make the decision, which decision is then binding. Subrogation clause. A clause giving to an insurer the right to pursue any course of action in its own name or the name of a policy owner against a third party who is liable for a loss which has been paid by the insurer is called the subrogation clause. One of its purposes is to make sure that an insured does not make any profit from his insurance. This clause prevents him from collecting from both his insurer and the liable third party. Assignment clause. An assignment is the transfer of a policy or some of the rights in a policy from the insured to another person or entity. The assignment clause states that the policy cannot be assigned or transferred to another without written authorization signed by an officer, not the agent, of the insurance company. Cancellation provisions. The insured may cancel the policy by returning the policy to the insurer or to the insurer's representative, or by notifying the insured in writing as to when the cancellation is to take effect. The insurance company may cancel a policy by written notice delivered to the insured or to the insured's representative for non-payment of premium, in which case notification must be at least 10 days before cancellation, or for any reason within 60 days of the application. If in effect for more than 30 days, the policy may be canceled on its anniversary date with 31 days written notice. Or the insurance company may cancel the policy at any time with 31 days written notice for discovery of grossly negligent acts or omissions by the insured, which increases the risk of the hazard insured against, or for operational changes in the insured's business or the covered risk, or for physical changes in the insured's property which result in its becoming uninsurable, or if the insured has been convicted of a crime which increases the hazard insured against, or discovery of fraud in obtaining the policy or pursuing a claim. Non-renewal provisions. The insurer may non-renew or conditionally review on a reduction of limits or on elimination of sub-coverages by giving at least 30 days written notice. Supplementary payments or additional coverages are payments which the insurer will pay over and beyond the policy's liability limits. These include legal fees for defending the insured if a lawsuit goes to trial, claims expense, first aid expense for others, damage to property or person of others when not legally liable, and loss assessment coverage. The Fair Credit Reporting Act is a federal law which requires an insurer, usually through an agent producer, to notify an applicant that there may be a consumer investigative report requested as part of the application process. If insurance is declined or rated as a result of the report, the applicant has the following rights: the right to obtain the name and address of the company which did the investigation, the right to see a copy of the report, the right to correct any misinformation on the report, or at least to register additional information with the investigating company.
Before discussing the types of casualty or liability policies, let's take a look at terms specifically associated with liability issues. First, legal duty is the obligation to conform to a certain standard of conduct, one which most rational people would follow.
Compensatory damages can be divided into special or speculative damages and general damages. Special or specific damages are the actual expenses incurred by an individual or entity as a result of lost wages or income, medical bills, or damaged property. General damages, on the other hand, are damages due to pain, suffering, mental anguish, and similar losses. Punitive damages are damages which are assessed in addition to specific and general damages as a punishment for extreme or gross negligence by the offending and liable party.
Gross negligence is reckless, willful, or wanton acts without regard to the safety of others. Personal injury consists of non-bodily damages suffered by an individual due to false arrest, slander, malicious prosecution, wrongful entry or eviction, or violation of a person's right to privacy other than by advertising or through the media. Advertising injury is damages due to libel, slander, infringement on copyrights, titles or slogans, or misappropriation of advertising ideas in the course of advertising products, goods, or services.
In insurance, the term attractive nuisance does not refer to the good-looking next-door neighbor who likes to sunbathe regularly or makes eyes at your spouse. Rather, it refers to property or an existing condition that is dangerous but attractive to the public. Examples include swimming pools, outdoor trampolines, or refrigerators with doors left on.
Negligence is a concept that has been developed through common law. The basic premise of common law is that most people have an obligation or legal duty to behave in a reasonable and prudent fashion. Failure to act in this manner constitutes negligence. If this negligence leads to the injury of another or to the damage of another's property, the negligent party may be held liable for the damage. In order for legal liability to exist, it must be established that negligence occurred, that there was actual damage or loss, and that the negligence was the proximate cause of the loss. A person cannot be held legally liable unless he or she had a duty to act and failed to do so, or failed to act correctly. In insurance, negligence is the failure to take reasonable care, precaution, or action to lessen risk exposure. Negligence may be the result of either omitted acts, such as failure to shut a window before leaving the house, or committed acts, playing catch with your child in front of a sliding glass door. There have historically been 4 basic categories of individuals which cannot be held negligent. They are infants, the mentally incompetent, governmental bodies, and charitable institutions. Recent legislation and court decisions have held that the government can be liable to the same extent as private individuals, and that charitable institutions are to be treated in the same manner as profit-making businesses. An individual's negligent behavior doesn't necessarily mean they have a legal liability. There are certain defenses that could free the person from legal liability in spite of negligent behavior. These include assumption of risk, comparative negligence, contributory negligence, intervening cause, and statutes of limitations. If a person understands the danger involved in a particular activity and voluntarily chooses to do the activity anyway, he or she can be acknowledged as having assumed the risk themselves, and this will bar recovery for possible injuries caused by negligence. If Rod is driving his car in a negligent manner and Sally is riding in the car saying nothing, Sally may be considered to have assumed the risk of injury. Contributory negligence signifies that any negligence on the part of an injured party will normally defeat a claim. A few states use the doctrine of contributory negligence. In auto liability, the most common example is that of jaywalking. The doctrine of comparative negligence is more lenient than that of contributory negligence and is also used by more states than the other. With comparative negligence, contributory negligence on the part of the injured party will not necessarily defeat the claim, but will be used in some way to lessen the damages payable by the other party. Comparative negligence has 2 schools of thought. The Mississippi rule, first used in that state in 1910, states that any defendant who is partly at fault must pay in proportion to their share of the fault. Most other states follow what is known as the Wisconsin rule, under which the defendant who is least at fault is not required to pay for any of the damages. The third common law defense against negligence is that of the intervening cause or last clear chance. Under this principle, the injured party would be able to collect damages even if he or she had contributory negligence, if the other party had an opportunity or last clear chance to avert the accident but did not do so. The fourth common law defense against negligence is the statute of limitations, which basically sets a time limit on how long an injured person can sue for damages. The injured party must act to collect for damages during the given time period or forfeits their right to do so. Fifth, the common law fellow servant rule states that an employer cannot be held liable for the actions of a coworker if an employee is injured due to the negligence of that coworker. Two final liability issues we will discuss are those of absolute or strict liability and that of vicarious liability. Absolute or strict liability is a legal doctrine that holds that an individual can be held liable even if negligence does not exist or cannot be proven. The injured party may collect damages even though there is nothing legally wrong with what the other person did or the manner in which they did it. A major example of this is workers' compensation. Most states require employers to be responsible for employees injured on the job, either through workers' compensation or through direct payments. If an employer does not have workers' compensation available, then common law defenses such as contributory negligence on the employee's part cannot be used by the employer to avoid paying damages. Vicarious liability arises out of imputed negligence, in which one individual becomes liable for the negligent behavior of another. Employers are generally held liable for the negligent acts of their employees, while those employees are acting within the scope of their employment. Insurance companies, as principals, are liable for the negligent acts of their agents.